All right, welcome to an oral argument session of the Fifth District Court of Appeal. I'm Judge Eric Eisnagel. We have on the panel with us today Judge Lambert and Judge Harris. The first case we have today is Williams versus State, 2406. And counsel for the appellant, if you'll let me know how much time you'd like in rebuttal, we'll try to give you a reminder.
Thank you, Your Honor. I would like 5 minutes for rebuttal if possible.
Okay. All right, counsel, whenever you're ready.
Thank you. May it please the court. My name is Rachel Reese and I represent the appellant, Derek Williams, in this matter. This is an appeal from the denial of Mr. Williams' motion for post-conviction relief. Originally, the two claims at issue before the court were summarily denied by the trial court, but this court later reversed that order, finding that an evidentiary hearing was appropriate. Mr. Williams had argued that his attorney was ineffective for providing him unreasonable advice about not testifying at his trial when that testimony would have been the only evidence in support of an independent act jury instruction. The second issue was that trial counsel was ineffective for not presenting any evidence in support of that instruction, and because of that, the trial court at the trial level did not provide the jury with that instruction. We ask that this court find that the trial court erred in denying both of these claims after the evidentiary hearing was held. Mr. Williams was originally charged and convicted with one count of first-degree murder. He and his co-defendant, Mr. Owens, lived together and their house had recently been burglarized prior to this incident. Upon learning of who the potential culprit was, an individual named Mark Williams, who I will refer to as the victim just for clarity purposes since they have the same last name, the evidence established that they devised a plan to go and confront the victim with an altercation, which they then did. The evidence at trial established that Mr. Williams and Mr. Owens met up with the victim, got into a physical altercation with him, and then the victim proceeded to flee from the scene and Mr. Williams chased after him immediately. At that point, his co-defendant went back to the vehicle that they had arrived in, retrieved a firearm unbeknownst to Mr. Williams, and then proceeded to run after the victim and ultimately shot and killed him.
What type of firearm was it?
Your Honor, that issue in trial was something that was in dispute. They were unable to decide which firearm actually did kill the victim. The evidence established that there was a very large, I believe Mr. Owens had made an admission that it was an AK-47 in the car, but there were several shell casings that were found. There was 380, 9mm, so many different ones that in the wound to the victim, they were not able to establish that. However, there was no evidence about what this, how available and appearance was the weapon in the vehicle when Mr. Owens took it out of the vehicle. It was
some type of a long gun, right?
Yes, it was. And that's what one of the eyewitnesses that had been watching from her apartment did say, that it was a long gun that she saw him retrieve. Now, during the trial, though, Mr. Williams' trial counsel...
What was your client's defense at trial?
So the defense at trial was that Mr. Williams was not part of the shooting. And
was it that he wasn't part of the shooting or that he wasn't there at all?
It's our interpretation of the record is that he was not part of the shooting. At the evidentiary hearing, however, trial counsel said that his strategy was that Mr. Williams was not present at all, which I believe the record speaks for itself, that the strategy was that he wasn't part of the shooting. And I actually have a record cite for that where he specifically goes over that. But the strategy would not have been a legitimate strategy to argue that Mr. Williams was not present at all, because of the fact there was evidence that, I don't want to say conclusively put him there, but there was an eyewitness who knew him, who put him there, said they saw him in an altercation with the victim. His T-shirt was found with his DNA. So there was a lot
of evidence that he was there. I understand, but did he was at the evidentiary hearing? Was there testimony that your client told his trial counsel that he wasn't there?
Yes, at the evidentiary hearing.
I think that's the important critical point here, right? I mean, if that were true? Let's say for a minute that's true. Then what is trial counsel supposed to do? If his client says, look, I wasn't there, the truth is, to his lawyer, I wasn't there. Well, what's trial counsel supposed to do?
So a couple things about that, Your Honor. The first point is that our position is, number one, that trial counsel's evidentiary hearing testimony is not credible. He went back and forth in his answers continuously. He contradicted himself. His testimony was that he didn't review any notes. He might not have even had notes.
But your post-conviction court found him to be credible more so than your client, who A, is an 8-time convicted felon, B, has apparently got on a jail call or interfered with a jail call and said that he did shoot the guy. So why isn't a post-conviction court, entitled to say, I don't think I really believe Mr. Williams. Do I have to pick between the two, which typically is what comes down to 3850 hearings, having presided over numerous of them when I was a circuit judge. The judge said, well, I think Mr. Blankner, I guess, is more credible. I mean, aren't we bound by that credibility determination? And in the context here, I mean, I guess if, there at some point we could probably ignore credibility determinations if, I find Mr. X credible and we find out Mr. X was actually in the North Pole at the time, then that's probably a bad call by the judge. But that's not what we have here, though. I mean, that's kind of the problem one of the problems you have here, isn't it?
Yes and no, Your Honor, and I understand the court's position on that. But in order for a credibility finding to upstand, this court is allowed to look at those findings and say, is this supported by competent and substantial evidence? And the answer to that, our position is no. Mr. Blankner had zero recollection of this case. He went back and forth. He even admitted, I might be wrong. And if I am, I'm sorry. So how are we supposed to?
I know, but it's contextual. I mean, again, I don't want to sound like, well, this old hat of mine that I did. It was always interesting to me as sitting as a circuit judge on these post-conviction evidentiary hearings that defendants would have a stunning recall of all these events years later. And then, the defense counsel, who's had hundreds of cases since then, may not have the exact recall. And then that would be the flag being waved saying, well, see, I'm much more credible because I, who have a very vested interest in how this hearing turns out, remember everything completely. And my defense counsel didn't. And you as a trial judge listening to that had the ability to say, well, okay, maybe your self-serving exact testimony isn't quite as credible as the lawyer who says, I'm doing my best to remember what happened 7 years later. Now y'all are asking me about this. I mean, that's a call that the judge has to make. I know, again, it doesn't help your side. And I get it, what you're saying about Mr. Blankner doesn't remember everything, but we're kind of hamstrung here a little bit on that, aren't we? From a review standpoint.
And Your Honor, I still disagree with that because I think even the record from the trial establishes that the only way that Mr. Blankner would have known of these facts was if he and Mr. Williams had a conversation ahead of time, because there was no other evidence that established the facts that he was trying to allege to get the independent act instruction. And this is just in support of the argument that Mr. Blankner is not credible. Even assuming that he is credible, or that we're supposed to accept that there is competent and substantial evidence of his credibility, which again, we are not conceding and we disagree with, assuming that what he said is true, that Mr. Williams told him he was not present at the shooting, the layout of this crime is something that I don't think has been given a lot of consideration, and it's extremely important. And I went back and read through the trial transcript several times just to make sure I wasn't misstating anything. This crime took place over 2 apartment complexes. The first
before you move on to that, let me go back to the previous point. You're saying that there wasn't much evidence for a finding that Mr. Blankner was credible. In fact, you're saying there was evidence that he was not credible. If that's the case, where's the evidence that your client was credible? If it's a weighing factor and the judge has to find which one's more credible, your client's the one, as Judge Lambert said, with the multiple felonies and previous inconsistent statements to law enforcement and the statement to the other inmate. And where's there any evidence from which the judge could find credibility of Mr. Williams?
And Your Honor, that's an interesting point. The court never actually found that Mr. Williams was not credible. They just found that Mr. Blankner was more credible. This wasn't a situation where the judge said, I don't believe what Mr. Williams is saying. That Judge Barber, who was the trial court judge, simply said that she found Mr. Blankner was more credible. And what's interesting about that is she could have just ended her entire analysis and findings there, but she went so far as to continue on. Even assuming I found Mr. Williams more credible and assuming beyond that, I think that's important for this court to consider, is that she never said that Mr. Williams was incredible or that she did not believe what he was saying. It was just that she thought Mr. Blankner arguably was more credible. Going back to the point about assuming that the statement is that Mr. Williams was not present at the shooting, This original altercation with the fight took place at the vehicle, which was the white Corolla, in one of the apartment complexes. The evidence at trial established that the witnesses saw the victim in this case run. He ultimately went into the apartment complex next door, which there was evidence that established there was a wooden fence that divided these two apartment complexes. And the only way to get to the other one was to actually jump a fence, which wasn't highlighted. At the evidentiary hearing, Mr. Williams testified that when he began to chase the victim, before he got to the other side, he slipped in the grass, which was supported by the original arrest affidavit, as well as the testimony of one of the crime scene technicians at the trial. She specifically testified that there was an area where the black t-shirt was found that had Mr. Williams' DNA on it, that there was a mark in the grass that for somebody looked like they had fallen. And that same exact thing, which we cited in our reply brief, was in the original arrest affidavit the day that all the evidence was taken up. It said like a slide mark, which supports everything that Mr. Williams is saying. So the fact that if we're assuming that Mr. Blankner is credible and what he's saying is true, then his remembering that Mr. Williams told him he wasn't present at the shooting is true and is supported by what Mr. Williams says, because the shooting took place in the second apartment complex on the other side of the fence. That's where the victim was eventually found when he ran up to his girlfriend at the time's apartment, and he unfortunately passed away, I believe, at her apartment. And so I think that's a big distinction that not a lot of credence has been taken, not a lot of thought has been put into it.
Are you suggesting that perhaps, are you saying that trial counsel misunderstood what your client was saying? When your client said, hey, I wasn't there, assuming that's what he said, right? Because that's what the trial court essentially decided. So if that happened, your client said, hey, I wasn't there. Are you saying that trial counsel just misunderstood that statement by your client? That your client really meant, I was there for the burglary, but not for the shooting?
I don't think it's misunderstood. I think it's misremembering. And I think that misremembering, it makes logical sense because it fits with the strategy at trial, is that Mr. Williams was present but didn't participate in the actual shooting. That's exactly the same thing as saying that he wasn't present at the shooting, because they took place in one general location, but two specific individual locations. So I think it's a matter of misremembering, which after 11 years and over 300 trials, which is what Mr. Blankner testified that he has done since then, I think that's a reasonable conclusion for this court to come to, is that it's just a misremembering of what actually he was told in the context of what he had looked over in preparation for the hearing.
Particular point argued to the trial court at the hearing?
I'm sorry?
Was this particular point that you're making now argued at the hearing?
I believe that it was, Your Honor. We argued that Mr. Blankner was not credible, that he didn't remember anything.
I'm talking about the whole, there's a, maybe it's both. Essentially you're saying maybe it's both. Maybe he wasn't at the shooting, but he was at the initial crime, and that counsel is misremembering. Was that specific point raised?
Your Honor, I don't know if it was specifically raised in that context, but the point was raised that this Mr. Williams' testimony from the evidentiary hearing would have fit very squarely into the strategy at trial, that he was not involved with the shooting, meaning he was not present. So yes, arguably, yes, it was presented. And had Mr. Blankner advised Mr. Williams reasonably, which is our position, Mr. Williams would have testified and would have been able to explain, in our opinion, is a very simple explanation. And it kind of seems odd to say it's simplistic, but it really is. At the end of the day, Mr. Williams' story makes sense. Mr. Williams went to an altercation and took off his shirt, which is a common act to do, that's what we see in some of these cases like that, as I'm sure your honors have seen. If somebody has the intention and a plan to go and eventually get out a gun and kill someone, the question is, why would Mr. Williams have taken off his shirt and left his shirt with his DNA for him to be found? It just doesn't make logically any sense, which is what Mr. Williams testified to at the evidentiary hearing. And again, the other evidence forensically and witness testimony actually supports what Mr. Williams is saying and is supported by the state's evidence at trial. So if he had testified and the jury had been able to be instructed on the independent act, there is more than a reasonable probability that they would have found reasonable doubt.
I guess, these post-conviction cases can be complex because we sort of have two different proceedings, right, that we're sort of trying to sort through. So we have multiple layers. But I mean, what you're saying might make sense as an argument to the jury at trial. But I think what we're talking about here is that evidentiary hearing where the trial judge concluded that your client told trial counsel, I wasn't there. Now, maybe everything you're saying is exactly how it happened. And maybe that's a great argument that could or should have been made at trial. I don't know, but that seems like an argument for trial. Now we're dealing with an evidentiary hearing where the question is, what did your client tell trial counsel? And if your client, even if all that stuff is exactly how it happened, if your client told trial counsel, I wasn't there at all, how do we reverse this? If that's what your client told trial counsel at the time.
Well, Your Honor, I think that we have to go based on what the evidentiary hearing says, and taking what Mr. Blankner said. He never said that Mr. William never told him that he was not there at all. His testimony at the hearing was that he wasn't involved he wasn't at the shooting. So I think that we're allowed to take that into context with the other evidence that was presented. And then the ultimate question is how that would have changed at the trial. And I think that we have to look at the hearing and we have to look at the trial transcripts. And that's why it's so important. And I think the other matter to consider with Mr. Blankner is that the court still went on to find, even if Mr. Williams was to be believed. So obviously the court went so far as to look at the merits, which is what we're asking this court to do, because Mr. Blankner's testimony, whichever way you look at it, credible or not credible, it still supports what Mr. Williams is saying and still supports the fact that if he was not present at the shooting, he forensically and evidence presented at the trial supports the fact that he was there. There is no way around that statement. There's no way around that fact. And Mr. Williams has never tried to deny that. So I think that alone provides the court a pathway to look back at the trial, to look at the evidentiary hearing transcripts, and to find the factual and the legal findings in this situation is what we're supposed to be looking at, is that Mr. Blankner was ineffective. And if he had provided effective advice and reasonable advice, that the only evidence that could explain why Mr. Williams was at the scene, the only evidence that could have explained why he wasn't part of the murder but was part of a fight, was if he had testified. And that is supported by the fact that Mr. Blankner requested the jury instruction, was denied, but he was adamant that that was what their defense was. And he went for pages.
This comes down to sort of like we're sort of splitting hairs a little bit, right? You're saying, well, look, I mean, the way that what my client said, what your client said could have been interpreted as, I wasn't at the shooting, but I was initially there. I mean, right? That's what you're saying. But isn't that what this case really comes down to? I mean, isn't that sort of the decision point? That whether or not we can reverse the trial court's finding based upon, potentially the record could be interpreted two different ways.
I don't think it's splitting of hairs. Mr. Williams has been very adamant that he was present, but he was not involved in the shooting. The defense at trial was that Mr. Williams was present, but was not involved in the shooting. At the evidentiary hearing, Mr. Blankner is saying that he remembers Mr. Williams telling him that he was not present at the shooting. He didn't say he wasn't present at all. So I think no matter what way you look at it, no matter what way you split the hairs, it's not. Everything goes to the same conclusion. Mr. Williams was present. He was not present at the shooting, and he was not involved in the shooting.
So based on that, present at the shooting, I mean, they got in the same car together and drove off, right? Do I remember that correctly? Right.
Correct, but the shooting happened at a different apartment complex, and I think that's something that is not being considered.
I mean, how far does the record reflect how far away that would have been? I mean, two, depending on where you are, two different apartment complex could be just feet away, right? It could still be.
And they were. It was a simple wooden fence that divided them, but that makes the world of difference. That Mr. Williams has fallen, the victim and Mr. Owens jump over the fence, and that is where the shooting actually happens. Mr. Williams has nothing to do with that, and that's what he testified to at the evidentiary hearing, and that is why it's our position that trial court erred. And if
I'm sorry, counsel, you're over your time for rebuttal, so we'll stop you there unless you want to keep going.
No, thank you, Your Honor.
I apologize for not noticing that earlier.
That's okay, Your Honor. Thank you.
All right, and so next we'll have the appellee.
My name is Pam.
Ready.
Thank you, Your Honor. My name is Pam Kohler. I represent the state of Florida in this appeal. I would dispute that the evidence is clear that Mr. Blankner knew about this so-called independent act version. When you look at his argument during the trial, when he was arguing for the independent act instruction, number one, he admitted he was flush with a recent win on this exact issue. with this court. And so, he comes in, that's what's happened. But when he argues to the court on page 548 and 550 of the trial, he's saying the common plan was to essentially locate the person who committed the burglary. It was not to beat the guy up. It was not anything like that. He argues that twice. It was just to try and find the person to talk to him, basically, to find out who burgled the house or his home. So the fact that obviously the only way he could have argued this is if he had been told this by his client is not true. I mean, you've got a very experienced trial attorney, criminal defense attorney, and he kind of patches together this defense, but also admitting that, an independent act defense is a lot harder to argue than the principle, because he would have to, in addition to arguing all the others, he has to argue contrary to principle that it was not reasonably foreseeable. And in this case, not only did they take a car and make sure that the car did not have expired tag, because the co-defendant didn't want to, if you're just going there to locate somebody, what do you care if the car has an expired tag? The likelihood of getting stopped by cops is pretty low. But if you've got an assault rifle and you're going to murder somebody, you are going to want to make sure you don't get stopped by the cops. So I would submit that the evidence is not obvious that the defense attorney was told this testimony, and that it was not ineffective to not go forward and push an independent act defense. As far as
Well, counsel, what was the evidence that would have supported an independent act defense at trial?
Well, what he argued was that the girlfriend had said when she got the defendant out of jail, we know who did it. The house was burgled. This is who did it. We think who did it. And he said, I'll take care of it. They all get together, the co-defendant and the guy who loaned the car and the girlfriend, and they discuss this. And they basically talk about the fact that she says, I'm going to call the cops. I'm going to call 911 because we know who did it. And he's like, no, we'll take care of it. And so the idea was that they wanted to locate this man on their own versus they want to take care of it themselves and not have the cops. The defense attorney argued it was not that they wanted to go kill the guy, that they just wanted to talk to him and find out who had burgled their house. And when he was screaming at George Chung at the jail, he was saying something, we were looking for you on the street. So, he used that as saying, yes, we were just looking for the people who we thought had committed this burglary, not that they were there to beat them up or do anything else, certainly not to kill them. It wasn't very strong. And part of the problem with this case is it not being strong is because this was not a felony murder case. You didn't have some other felony that had been committed. This was purely a premeditated murder case. There was no other alleged felony committed. So that makes it, as the judge pointed out during the trial, that makes it a lot harder to sustain an independent act defense. The trial attorney also was more consistent than the defendant, because the defendant alleged in his motion under oath and would not admit that it wasn't what was true, was that he had, once his attorney told him he shouldn't testify, he thought that's what he had to do. He had no choice. And then he gets to the hearing and says, well, yeah, no, I agreed to not testify, to waive that right to testify. And then he had also alleged, as far as the second claim, that he had told the police he was a participant in a plan to fight the victim with no idea the co-defendant had a gun. And then he got to the hearing and he said, well, no, my statement to police, I denied knowing the victim. I denied knowing even that apartment complex. I didn't know anything about it.
Well, here, it's a two-step process about, why I didn't testify.
Sure.
Was it voluntary? And I think it's pretty clear from the record that the defendant voluntarily chose not to testify. The second step, though, is even if voluntarily followed, was the advice so deficient that no reasonable attorney would have discouraged the defendant from testifying. So, isn't that the burden the appellant has here? Is that basically what Blankner told the defendant not to testify, or advised the defendant not to testify, that nobody else would really suggest that at all? This is just such an anomaly that it's so unreasonable that it therefore rises to the level of relief under Strickland. That's kind of what we're facing here reason
Sure.
why we should reverse this or not, right?
Right. And I would also submit, I mean, he explained, he said, even if I'd known about this, I wouldn't have had my guy testify. He said, number one, he'd be impeached with his prior inconsistent statement. Number two, he'd be impeached with his 8 prior felony convictions. Plus have to basically explain why he's screaming at George Chung. I know, don't you know who I am? I killed your homeboy with a firearm. So, I mean, basically, and I would submit that it was that confession is what impressed this jury most of all. The fact that no one else had seen this defendant with the firearm. All the other witnesses said it was the co-defendant had run back and gotten the long gun out of the car and took off after them. And so there was no testimony. So the only evidence they had that the defendant was the one who had the firearm and shot and killed this victim was his own confession when he was screaming at George Chung on the telephone. And in fact, that's another reason actually would be a good reason not to have his defendant come up and testify to this is this was a joint trial and Mr. Blankner testified at the hearing. We proceeded to trial with Mr. Owens. There was always an issue of what Owens was or was not going to do. So he shows up, no idea what the co-defendant's going to say. Now, if Mr. Williams had got onto the stand and said, no, I didn't know anything about it. We were just there to beat the guy up. It was my co-defendant who had the firearm and shot and killed this guy. What do you think the co-defendant would have done? I mean, they were basically on the same page during the trial. I mean, they made the same objections and their closing argument was basically very similar as far as why they couldn't be principles to this crime. And the jury ended up finding that this defendant, not the one who was actually witnessed to be in possession of the firearm, actually possessed, discharged, and shot and killed this victim. The co-defendant was not found that. The jury did not make that specific finding. They found he possessed the gun. So the evidence, if this co-defendant decided to then testify, it would have been consistent, presumably, with the jury, with the confession by the defendant, because he would have said, yeah, man, I grabbed the gun, but then we went running after him. The defendant asked me to give him the gun and I shot and killed this guy. And because that's exactly what the jury found. So had the defendant testified, I submit to you, the co-defendant would have gotten up and testified at that same trial and said, no, man, he's the one who shot him and killed him. He even admitted to it over the phone. And the jury would have reached the same conclusion. So,
Ms. Kohler, you're saying that incriminating statement to Mr. Chung was so influential with the jury in this case. Isn't that more reason why perhaps Mr. Williams should have been given a chance to testify to explain why he made that statement? I mean, he's got a reason for it.
Well, and the defense attorney made the reason, but again, you put him up there, then you've got to have him explain his, the fact that he's a convicted felon and that he lied to the police and that, he made these horrible statements and tried to explain it, which the jury, I think they heard
those statements are so damning, like you say, the only way to explain them is to get on the stand. And there's risk with that, obviously, but the only way to do it is to take that risk, right?
Well, again, that's strategy. That is trial strategy. I mean, I understand the defendant gets the final version, but that is trial strategy. And I disagree. I mean, he did not make a very good witness at this hearing. He wouldn't even admit that, even when this defense attorney said, it was just a typographical error that you put all those, misrepresentations in your motion, and he wouldn't even agree to that. So, I mean, he was not he couldn't remember how many prior felonies he had. He just was not a very good witness. And so I would submit that I disagree that you do not want to expose your client when you're going in thinking that your client's going to testify consistent, especially if you think your client's going to testify consistently with what he gave the police statement about. The last thing you want to do is have him exposed to the fact that he's a convicted felon 8 times over, and trying to explain why 2 years later as the prosecutor argued during closing argument, is the first thing he mentions to George Chung isn't the fact that he slept with his baby mama. It's that he burglarized his home and he was looking for him and that he killed his homeboy. So he's still pissed 2 years after the crime, and to the point where he's screaming at George Chung, doesn't care he's being recorded at the time and that it was going to end up being used against him. So, I mean, I would submit that it was probably best for this guy to keep his mouth shut and to try and get on the stand and get cross-examined by the state of Florida to try and explain why he would threaten to kill this guy like he killed his homeboy, and basically showed who he truly was. I mean, I think it gave the jury a view into who this young man really is. And he basically was, you crossed me and you're dead. And that's what happened to this victim. If this court has no further questions, I would rely on my brief and ask that you affirm. Thank you.
Thank you, counsel. All right, and counsel for the appellant, I think you have about a minute and a half, minute 23, whenever you're ready.
Just 2 points to follow up with. First of all, I just wanted to note on the point that Mr. Blankner had no idea what the co-defendant would have testified to if Mr. Williams had taken the stand. It's our position that, number one, that's irrelevant because we have no idea what that would have been. And it's speculation at this point. And number two, the fact that Mr. Blankner admitted at the evidentiary hearing that he had no idea what Mr. Owen's defense was going to be, even though they went to trial together, I think speaks for itself about his preparation for this trial and whether or not he had thoroughly thought through what his defense was. The second point is just kind of piggybacking off of what Judge Harris was saying earlier. The statements that were made by Mr. Williams were the most damaging pieces of evidence against him. The jury found him guilty of something that was not even argued by any other piece of evidence except for his own confession. No other piece of evidence put the gun in his hand except for that statement. The only way that the jury would have been able to have had an explanation for that is if Mr. Williams would have taken the stand and admitted it. And it's our position that any prior convictions, any other negative impact of that would have been outweighed by the probative value that it would have given the jury, because it would have given them reasonable doubt and it would have offered them an explanation for why this person who is telling law enforcement he wasn't there was clearly there. It would have actually made him look more credible if he came forward and offered the truth and an explanation for the jury to consider. And it's our position that the trial court erred because he would have been found not guilty if he had testified. So we would ask the court to vacate the trial court's order and reverse with directions to vacate Mr. Williams' judgment and sentence. Thank you.
Thank you, counsel. All right, and with that,